Welcome to the UK-USA Transatlantic Tax Talk podcast, brought to you by Coyle Bristow. I'm Aidan Grant, a partner in our Trust Tax and Estate Planning team. In this series, we explore the complexities of UK-US tax and estate planning, helping individuals and families navigate cross-border wealth with confidence. From wills and trusts to philanthropy and moving to the UK, we cover it all and always with a US perspective. Let's get started. This is Coyle Bristow's US-UK podcast. I'm Aidan Grant, and we like to use this space to talk to interesting people within the tax and estate planning world for Americans living in the UK. Can I encourage you to hit that subscribe button if you're listening through a streaming platform? Today we're going to think about the LGBTQ community and what tax and estate planning issues arise for their members. I have the pleasure today to be joined by Ryan Coyle, partner at US law firm Bilzin Sumberg. Ryan works out of their Florida office and specialises in tax and estate planning for high net worth international families. Relevant for today's discussion, Ryan is also the current co-chair of the LGBT Committee of the International Bar Association, an organisation to which he and I are both members. And so he has acute experience and expertise when it comes to think about the individuals within this community and the issues they face. Ryan, it's an absolute pleasure to have you on. Thank you so much for coming along today. How are you?
Thank you for the invitation, Aidan. Doing well. Thank you very much.
Great. So there are several different ways, you and I discussed several different ways that we can cut across the various issues that come out of here. And what I suggested that we do is maybe think about these things sort of more thematically rather than technically. And so what we're going to do to signpost for the listener is we're going to think about broadly 1, 2, or 3 different areas. We're going to start by thinking about the individuals themselves, some hypothetical individuals who are making their estate plans, be they a same-sex couple of themselves or not, and thinking about things like the centrality of marriage in that estate planning. And then in the second half of this episode, we're going to think about some of the recipients of that estate planning and how that can require some particular issues with LGBT families, with children, with trans beneficiaries, and so on. But Ryan, I'm going to take you to the point I mentioned first, which is thinking about where tax and estate planning started historically, which is for families which, in a traditional sense, would have meant a married couple. Am I right that a US law like UK law is still, to this day, largely baked into the idea of a traditional nuclear married couple?
Yes, I would say that's right, both on the U.S. tax side as well as on the U.S. property side. So again, you're completely right that historically and even today, one of the first questions we might ask a client relates to, are you married? Do you have children? If you're not married, do you have a partner? That sort of thing. And these questions are relevant to any client, and so that includes any LGBTQ client that may come our way. Marriages, I think, it's an interesting topic. As you mentioned, thank you so much for the introduction. The LGBTQI plus Law Committee of the IBA has treated extensively over the years with respect to the UK and the US. The issue has somewhat receded as I shouldn't speak for all of the jurisdictions, but as a less controversial one and a more accepted one within the two jurisdictions. So really the question becomes kind of what is the take-up on marriage among same-sex couples as opposed to opposite-sex couples? And we see in the US, and I think it's similar in the UK and in many jurisdictions with marriage equality, that rates of marriage are lower among the LGBTQ community. And this has certain consequences for estate planning. So I think we'll talk about many of those today. On the income tax side in the US, for example, married couples are permitted to file jointly, which can have certain advantages in terms of higher standard deduction or amount of income that an individual is not required to pay income tax on. That's higher for individuals that file jointly, and you can only file jointly if you are married. I do quite a bit of work, as this podcast would suggest, in the cross-border space as well. So it's not just married couples, it's married couples that are U.S. tax residents. So sometimes we have, a couple, one of whom is U.S. tax resident and one of whom is not. Many times we see this as part of, pre-immigration tax planning. Aidan, I'm sure you see this as well, where filing jointly may not be possible even for certain married couples. But I think, for today, we'll assume that our hypothetical same-sex couple here, both members are U.S. tax residents, so they may be able to file jointly. Again, as in many jurisdictions, the income tax rates are geared towards various income brackets, and those income brackets are significantly expanded for married couples. Depending on the particular income situation of the two individuals or two members of the marriage, there can be pros and cons to filing jointly. But for the most part, there are advantages to filing jointly. for a variety of reasons, but in particular because of those expanded income tax brackets. So the rates are marginal in the US, marginal rates of up to about 37% now. Of course, it's a very political number and changes quite a bit. But in order to get to that 37%, a married couple filing jointly must earn significantly more income, about double, you might say, than a couple that's together unmarried and so thus filing separately.
The bit you pointed out there at the very end is really where this all starts, which is there is an impression, and sometimes, certainly in the UK, a misguided impression that there's such a thing as like a common law marriage. I mean, certainly in the UK, common law marriage as a concept hasn't really been around, I think, for something like 700 years. This idea that a long-term cohabiting couple of any description and also of any relationship type, two sisters in their 70s who've been cohabiting for 50 years any more than a romantic couple who just happen to cohabit because they haven't got married or entered a civil partnership. There is this dichotomy between how the law provides certain allowances, benefits, exemptions to this couple because they happen to have entered into a legally binding contract, as opposed to, an unmarried couple. And I know as a lawyer, I sound very unromantic by referring to marriage as a legally binding contract, but that's what it is. And this has been improved and options have been made more varied by the raising up at various points in the last 15, 20 years of things like civil partnerships to same-sex couples or heterosexual couples. But for many, many, many years historically, well within the living memory of people still practicing in law, this was an issue because marriage was only open to heterosexual couples.
That's right. There are I think we'll talk about some if we have time during this particular podcast, but some benefits that may be available to unmarried couples, whether same-sex or otherwise. But from a tax perspective and from a property perspective within the U.S., marriage is really fundamental to creating certain benefits that are guaranteed within the law, absent any of the estate planning that lawyers may prepare for them. So you're right. It's a very important issue. One thing I would add that's very important with respect to estate planning for married couples is this sort of concept of, for estate and gift tax planning, marriages is really fundamental. So generally, at a very high level within the U.S., besides income tax, there's a transfer tax that applies to certain gratuitous transfers from one person to another, usually called a gift tax during life or an estate tax upon death. So those sorts of transfers are subject to a gift or estate tax at marginal rates of up to 40% to anyone except for your married spouse. And so there's an unlimited marital deduction for transfers to your spouse, which from a practical perspective, Aidan, you and I think a lot about death, a little bit morbid, but even during life, there are many times when couples, and if couples are not married, unmarried couples will unwittingly transfer gratuitously to their partner or to their spouse. And so unmarried partners or couples really need to be careful about these sorts of gifts or gratuitous transfers that may be treated as taxable gifts in the U.S. Opening a joint bank account, for example, you sort of need to consider who funded the account. And theoretically, if wealthy partner one opens a joint account with less wealthy partner number two, that could be deemed as a gift from one to two. So we just need to be careful about that. It tends for, the average person, it tends not to be super relevant because there's an exclusion for transfer tax. It's indexed for inflation, but for 2024, it's about 13.6 million. So, in the average course, the average person is not too concerned, but for many of our private clients, it's a serious concern, both during life and then in particular upon death. So we just need to be careful that any transfers to a non-spouse upon death or during life are dealt with appropriately. There are a number of sort of technical solutions for that. I think the point is you have to plan for it. It's something that married couples enjoy automatically that unmarried couples do not.
I could not help but jump in and, of course, seek to elaborate on the otherwise excellent summary you gave of estate tax to point out that you are generous to your surviving spouse or your recipient spouse. You are less generous to your surviving or recipient spouse where that person happens not to be an American. So for all of the Americans who move over to the UK and, find a non-US husband or wife or same-sex partner, be they British or otherwise, you're not going to be quite so generous. So I do sometimes, I hasten to sort of point it out on this episode, but I sometimes refer to a mixed marriage in this scenario, in a tax planning scenario, as being where an American marries a non-American. That can have different connotations in different sectors, but there are particular issues that will arise where you've got a blended marriage from a nationality perspective, for you, let alone for a same-sex couple.
That's right. And if I could just add a little bit more of nuance to that point, which is relevant for cross-border couples, you're completely right that this unlimited marital deduction only applies if your spouse is not just a U.S. tax resident, but a U.S. citizen. So again, without getting into that, it's a much larger topic about U.S. tax residency. All U.S. citizens are U.S. tax residents, but not all U.S. tax residents are citizens. So Aidan, in your example, it's very likely that a sort of blended couple or a multi-jurisdictional couple, even if the non-U.S. half of the couple moves to the U.S., they're likely not a U.S. citizen, certainly not at the beginning. And so even though they may be a U.S. tax resident for income tax purposes, they may be a U.S. domiciliary for U.S. transfer tax and gift and estate tax purposes, still, if they're not a U.S. citizen, then you're right. This unlimited marital deduction for transfers from one spouse to another don't apply. So that's kind of a little bit independent even of this marriage discussion, because it's not only a matter of marriage. There's that second factor that the donee, the recipient, must be a U.S. citizen.
You'll find, I've come across it, I imagine that you will have come across it as well, that if you are in the presence of a couple who would say, look, marriage is not something that we're considering, or it's not for us for whatever reason, from an estate planning perspective, if they're a wholly domestic couple, they may say, well, what does it really matter? We're not within the $13 million allowance, let's say, for example. Does it really matter from an estate planning perspective whether we're married or not, because we're all under the allowance anyway? If that couple moves to the UK, notwithstanding they may keep their US citizenship, they're bringing themselves inside the inheritance tax net, and our allowances are considerably lower than the estate tax allowance. We're looking at per individual, in dollar terms, maybe $500,000 per person, in fact, less at current exchange rates. And so that issue of is it worth getting married is a much lower bar for an American couple in the UK than I think it would be as an American domestic couple, because that much many more people are exposed to inheritance tax, which is why I have certainly had this discussion. It feels the least romantic thing that you can possibly do, but maybe met with an individual who is desperately unwell, maybe doesn't have long to live, and has a partner, a romantic partner, saying, what things can I do to manage my exposure to inheritance tax at my death? And usually number one on that list of things I might say is, could you bring yourself to get married? So, deathbed marriage is going to be treated the same for inheritance tax purposes as a couple that's been married for 50 years. And it may only be a tax deferral mechanism, but if you're young enough where your surviving spouse partner is going to survive many more years, that's many more years of an opportunity to carry out tax planning that wouldn't exist because you have, consciously or inadvertently chosen to live as an unmarried couple. And it's never an easy discussion, but you have to advise people. So you have to give them the options, and then they have to take the decision.
That's completely right. And one other point, I'm glad you raised kind of the difference in exclusion amounts for the estate or inheritance tax between the US and the UK. One thing I would mention is that we're seeing quite a bit, those of us on the U.S. side and those of us outside of the U.S. who advise U.S. tax resident clients like you, Aidan, is the sort of sunset planning. So without getting too technical, there are many changes that were brought into effect by the recent 2018 tax reform in the U.S. One of them was an expansion of this exclusion for transfer tax purposes up to, in 2024, $13.6 million. That's set to halve at the end of 2025. So it's a bit of a use it or lose it proposition. Of course, we don't want anyone to die before 2025, but there are certain irrevocable or completed gift transfers that can be made between now and the end of 2025 that are very interesting for clients that have been considering planning for a long time and kind of putting it off. They may be relatively young or healthy or have other priorities. Now is really the time, now in the next year and a half, to implement these structures, because if the completed gift or the irrevocable transfers are made after 2025, they don't benefit from the same exemption amount. It will be about half as much. It's a very political number. It's conceivable that after the U.S. presidential elections this fall, that there could be a new Congress and a new president who has a different view on these sunsetting provisions, including this exemption amount, but it seems unlikely. We got tax reform in 2018, and it was the first time in a long time. And so I don't anticipate that the political will is there to change anything. So sunsetting really just means something will happen automatically to a law, in this case being repealed, if Congress does nothing, and it seems likely they will do nothing.
You said, planning may take place in the next 18 months. I imagine, speaking on behalf of Ryan, as his spokesperson, that if any of Ryan's clients or colleagues or intermediaries are thinking about this, when Ryan says at some point over the next 18 months, I'm sure what Ryan means is damn well with enough time before the end of next year to complete this planning so that Ryan is allowed to have his Christmas in 2025. Please don't come forward on the 30th of December and go, what did you say about that estate allowance going down at the beginning of 2026?
Thank you, Aidan, for mentioning that for personal reasons, but also it's good to mention for any other advisors who may be listening, bankers, accountants, wealth planners, to also raise this issue, because you're right, there will only be so much capacity for estate planners, lawyers in particular, drafters, towards the end of 2025. Aidan, I know there's some changes coming down the pike in the UK that you'll be feeling the pain in the next year or so. So I'm sure we'll be able to commiserate.
It makes us busier, but busy is not always a universally good thing. What I think would be useful, and as a comparison and contrast, I mentioned that historically, the issue of marriage, particularly within the LGBT space, has been a complex one that has opened up in the last 10, 15, 20 years. It is certainly the case in the UK that civil partnership has been available and has been treated on a par with marriage now for, I think it's 20 years. And then subsequently, over the last 20 years, firstly, the institution of marriage was opened up to same-sex couples, and then a civil partnership option was opened up to heterosexual couples. That process has, I believe, been the same opening up in the US, albeit, it's been a potentially more political hot potato for the US. But that is an opportunity that has been opened up now in the US, hasn't it?
So for civil partnerships, civil partnerships is something that we saw. So one thing I would say about marriage, or any sort of approximation of marriage in the US, is that it's generally governed under state law at any of the 50 US states. So each state is different. So in Florida, for example, where I practice, seeing sort of common law marriages or partnerships is not something that sort of comes across my desk on a regular basis. It existed, my understanding, in certain other states that are community property states before the advent of marriage equality. It was actually kind of a challenging issue to plan around. And I say that not speaking for the UK, where I don't have direct experience, but I do quite a bit of work in Latin America. And many civil law jurisdictions have this concept of a stable union, sort of like a civil partnership or something, which begins, not upon the formality of a marriage ceremony, but simply living together. So I think that's less of a concern in the US, but it is an important concern in many jurisdictions where relatively informal, as the couple may see, decide to move in together, and that triggers certain property rights as between the spouses. Usually it's, one that's particularly wealthy and one that's not, that may be inadvertent. So that's something that I think advisors in the US and in other jurisdictions that don't deal with those sorts of informal property arrangements as much need to be aware of. I became aware of it in the worst case of it, a founder of a very prominent company in Latin America went from, it's a regular guy to, a billionaire overnight. He and his girlfriend had been living together. They were close, but under this local jurisdiction's law, she suddenly had a right to half of his assets. He couldn't even disclaim them without a gift tax consequence in that jurisdiction. So I'm just saying, U.S. listeners who may be used to sort of looking out for formal marriages, be careful when you're working in other jurisdictions where property rights may accrue even without a formal marriage.
We are going to come to think about what do we do when we deal with institutions and jurisdictions that don't have the same sorts of, the US and the UK are largely aligned in this space, but, maybe don't have such forward-thinking rules. The thing I want to make sure we also touch on, because we've sort of skirted around it by reference to it, but without actually addressing it head on, is to forewarn of the consequences of what can happen when you don't have your planning in place, and how that can be particularly risky where you are an unmarried couple. Certainly for UK purposes, where someone dies without a will, we refer to them as dying intestate. Estate is then governed by the intestacy rules rather than by the provisions that they appear in their will. And the rights of a surviving, cohabiting, unmarried partner are non-existent under the intestacy rules. You do not feature. The individual's estate, your deceased partner's estate, will pass to children, parents, brothers, sisters, nieces, nephews, cousins, aunts, uncles, everyone else down the family line, and at no point does the cohabiting partner get a look at under the intestacy rules. you have a potential chance of making a claim against the estate for financial provision under what's colloquially known as the 1975 Act in the UK. But that is by no means a given and is something that you have to actively claim. And so this is Aidan's certainly pitch to forewarn and put on notice cohabiting couples who think, well, it's okay, we don't need to make a will, or, well, we might get round to it, we're not sure. There is that sword of Damocles that is hanging over your head that not having your affairs in order, either make a will or get married, or ideally you do both, this is your chance to do it. I presume, Ryan, there are similar risks in the US.
Yes, that's right. The same sort of intestacy rules apply to individuals who die without a valid will. Again, wills are governed under state law, so there are different formalities required by state. There's a lot of law that varies on, we see this a lot in Florida, where someone will prepare and sign a will under New York law, say, or Illinois law, and then move to Florida for retirement or otherwise. And there are certain rules within Florida that will determine whether or not the will adopted validly in the home state is valid in Florida as well. But normally it's not a problem. But yes, unmarried partners are not generally included in the intestacy rules. And the intestacy rules are a little bit old-fashioned in the U.S. anyway. And the idea is to sort of imagine, all right, so we don't have a valid will for the decedent. How would the decedent have wanted for his or her assets to have passed? Generally, that's to a spouse and children. But for whatever reason, those rules tend to exclude, even as you said, unmarried partners. One thing I would mention from the other side, so generally we want our clients to have wills sort of govern what happens to their assets when they die. However, many states, including Florida, have sort of elective share rules. So the U.S. generally does not have forced heirship rules. You sort of have freedom of disposition upon death, subject to a few exceptions, and one of those is an elective share rule. And in the U.S., the way that functions is that a surviving spouse has a right to claim up to 30% of the decedent's gross estate. So that could be relevant for a couple that is considering marriage if you're representing the wealthier half, so that the client knows if you do get married, your spouse, when you die, will have a right to 30% of your assets. So that's maybe one reason to consider not getting married. There are a lot of considerations that are unromantic relate to entering into a marriage or not. That's one of them, just to be careful about the elective share. But in any case, this applies. Intestacy rules are very important for LGBTQ couples because, as we said at the beginning, they tend to marry at lower rates. And so it's just important to work with an estate planner to approximate the rights that would apply to married couples with something like a will.
Although the one saving grace to all of this, and this is certainly the case in the UK, which is if you have a couple who are unmarried and don't make a will, the substantial asset is very commonly the family home, the home that the couple shares, and very commonly that home will be held jointly. And certainly in the UK, where an asset is held jointly, and by jointly here I mean what we refer to as by joint tenants rather than by tenancy in common. But if you hold an asset as joint tenants, then the surviving co-owner has an automatic right of survivorship, and that will override what occurs under the intestacy rules. It will also override what you put in a will. So if I say in my will, I leave everything to my brother, but Ryan, you and I own a property together as joint tenants, then your right of survivorship trumps what I put in my will. And if 90% of my estate is my property, you are getting 90% of my estate, and my brother, sorry to my brothers, are only getting that 10%. Presumably there are similar rights of survivorship that will override some sort of degree of the default intestacy rules?
Yeah, so that's a great point. So when we were talking about intestacy rules, we're talking about assets that pass pursuant to the U.S. would call it a probate process.
Yeah.
But there are many assets that pass outside of probate. And frankly, as an estate planner, we try to limit the assets that pass under probate as much as possible. Yes. So as you mentioned, joint ownership is an important one, especially for married couples. Transferring assets to trust also generally works to avoid probate, at least in the U.S., is sort of a slow, expensive public process. And so it's best to avoid it if possible or if well advised. There's one other thing when you mentioned the joint tenants, Aidan, that it's an interesting aspect of Florida law. And I think there are 21 states that offer a special type of joint tenancy to married couples. Mm-hmm. So again, getting back to the importance of marriage, called tenancy by the entireties, T by E, we oftentimes call it. There are a number of requirements for an asset to be titled as T by E. One of them is that you're married when you acquire the asset. But there's this incredible issue we haven't really touched on yet. We've talked about tax, we've talked about inheritance, but asset protection. T by E offers incredible asset protection for married couples because under U.S. law, joint tenants, if one joint tenant is sued, generally a creditor has access to about half of the interest in that joint tenancy for T by, regardless of the liability of the other joint tenant. In contrast with the T by E or tenancy by the entireties, both spouses have to be liable to the creditor in order for the asset to be available to them. So, for example, if spouse one is driving on the road and gets into a car accident and it's spouse one's fault and is sued, if spouse two is not liable, then any assets titled T by E are not available for the person suing them who was part of the accident, because technically under the T by E theory, each joint tenant of the T by E owns the entirety of it, and you can't take away from the non-liable spouse any part of the interest. So, Aidan, to your point, in Florida, we would call the primary residence a homestead. There are two really protections for the homestead. One is T by E if you can manage it, and two is a separate concept, maybe to say very briefly called homestead, which is a very state-specific provision in Florida. It's under the Florida State Constitution. It's incredibly generous to debtors, incredibly generous. There's the wild stories about OJ moving to Florida and buying a house and trying to shield some of his assets, if you remember that from ancient history. But it really is a powerful tool for both private clients and for typical Floridians to insulate their assets in the U.S., which, as we may know, is a highly litigious society where it's important to protect assets to the extent we can.
That said, I appreciate that what you and I have just discussed is all these ways that if people don't make wills and don't think about their estate planning carefully, they might be saved. I think we would both still say, think about your estate planning proactively. Don't rely upon some default rule to maybe save your surviving partner. Whether or not marriage is for you, that is a personal decision. And whether or not maybe a civil partnership in the alternative is for you remains a personal decision. But take those decisions in full possession of the facts, knowing that is what you want to do, and then plan accordingly around it. Don't be driven by your estate planning, be driven by your wider objectives, but your estate planning should meet your objectives. I want to turn us slowly now towards the other half of an estate plan, thinking about the recipients of that estate plan, particularly things like children, and where complexities can arise with greater prevalence in LGBTQ families. And where I want to start us is by thinking about those jurisdictions which don't have rules that are quite so similar to the US and the UK, and thus what do we do when we have more international families? So you mentioned in our first half a topic that actually we haven't touched on that much yet in this podcast series, but you talked about forced heirship rules, which appear in lots and lots of countries. Why don't you talk us through kind of what forced heirship rules are in very broad terms and where they currently come into play?
Sure. So forced heirship rules are, from a U.S. perspective, a relatively foreign concept, but the idea is that when an individual dies, the decedent is required to leave his or her assets to certain people or certain classes of individuals, usually spouses or families. So as we discussed, again, at a high level in the previous episode, in Florida, where property dispositions, bequests at death are governed generally by state law. So Florida has something called an elective share, which is common in many U.S. states, and a surviving spouse generally is entitled but not required to take up to 30% of the decedent's taxable estate, the gross estate. So that's a little bit of a forced heirship rule, but it really is nothing compared to what we see in many non-U.S. jurisdictions with which we work quite a bit. And it's important, I think, for U.S. and Aidan, you can confirm U.K. advisors as well to think about, because it may not be instinctual given our local training, but it is very important when we're working with cross-border families who have assets abroad and from jurisdictions in which there are much stricter forced heirship rules. For example, there may be a certain percentage of assets that are required to go to spouse and children, regardless of any other contradictory intent of the testator. Because, we tend to sort of think, the freedom of disposition, freedom of contract, we can just sort of make assets go wherever the client would like. That's not always the case. We'll talk about that a little bit more. One thing I did want to say, even on the U.S. side, again, this is property law is such a creature of state law in the U.S., but Florida has this very challenging provision that generally respects, well, I guess it's less forced heirship, but it's more community property rules. So Florida is a separate property state, but many of the clients that I represent from Latin America come from community property jurisdictions, which provide certain property rights to your spouse unless you elect out. But Florida So we have this instinct that property within a married couple, LGBTQ or otherwise, is separate and thus free to be disposed of however the title holder would like. Florida says, okay, fine, we are a separate property state, so you have those rights, unless the property was acquired when the couple was in a community property jurisdiction. In that case, Florida will respect the local jurisdiction's community property rules. And so then you become a Florida lawyer trying to sort of understand non-U.S. law. That's where we work very closely with local counsel. But just to say, the U.S. state planners in separate property states, which is the vast majority of U.S. states, tend to think that they have all sorts of freedom with respect to the testamentary intent. That oftentimes is true, but is less true with respect to international clients.
In the UK, we have a broadly similar set of rules that govern the law of succession of a given asset. We break it down between movable assets, which is most of your stuff, and immovable assets, which are basically your land and your real estate. Your land and real estate, the law is governed by the country that property is in. So UK land and property will always be dealt with under UK law. If a client of mine has a condo in Tampa in Florida, we would say, as a matter of UK private international law, that property's succession is to be governed by Floridian law. If I have a chateau on the south coast of France, that property's succession is to be governed by French law. My movable assets are governed by my domicile status, or the law of the country of my domicile status, where I intend to remain indefinitely as a general rule, and we give that the fancy Latin name lex domicilii. So I could be a French person living in the UK or an American living in the UK and have a UK bank account, and technically speaking, the succession of that bank account is going to be governed by the law of my international domicile. I mention this because in those circumstances, either where I'm, a foreign domiciliary with movable assets in the UK or a domiciliary anywhere, but with a property, let's say, abroad, the succession of that could be governed by a country which has forced heirship rules, for example. So I mentioned France very intentionally because lots of European countries have forced heirship rules. And if I leave my French property to my surviving spouse, let's use spouses for the time being before we make it more complicated, but if I leave my French property to my surviving spouse, French law may say, no, you are obliged to leave some of that to your children. Whether there are ways to alleviate that or mitigate that is a separate question. But by default, that is a risk. Now, as you've rightly pointed out, Ryan, if my client's condo is in Florida and Florida itself has testamentary freedom, then you're not going to mind, so we're not going to mind. But that won't always be the case in lots of countries. It certainly won't be the case in lots of EU countries, and it certainly will be the case in lots of Islamic countries, which are governed by Sharia law, because Sharia law is very, very rigid on making sure that different amounts pass to different members of the family and can make unequal provision for sons versus daughters, for example. That is presumably going to be even more complicated when dealing with 50 different states, because you're also going to have different rules for different states.
That's right. It's even more complicated when dealing with LGBTQ couples and jurisdictions that may not recognize same-sex marriages.
Yes.
So, for example, as you say, in Europe and the Middle East, there are many forced heirship regimes. Same in Latin America. I think Latin America has similar regimes, largely adopted from the French Civil Code, Napoleonic Code. But we see them a lot in Latin America. And certain of those Latin American jurisdictions also do not recognize same-sex marriages, certainly none performed within the local country, but even those performed abroad where they are recognized. And so I'm working with a client now, a same-sex client who was married in the U.S., but moved to the client's home jurisdiction to handle some family business affairs. It's a little bit of a complicated fact pattern, but via surrogacy, which maybe we can talk a little bit about later, the same-sex couple adopted 3 children in the U.S., and the client had a child from a prior opposite-sex marriage in his home country. And this home country has very strict forced heirship rules, which, frankly, for this client, if his local jurisdiction would recognize his 3 children via surrogacy, he would be happy to oblige. He would like his children to inherit in equal parts. But because his local jurisdiction does not recognize his 3 children via surrogacy, his concern is that all of my assets will go solely to my first child that the local jurisdiction will recognize. So we're working very closely with local counsel, both on the tax side, but also on the family law side, sort of getting the U.S. birth certificates transferred into registered really in the local jurisdiction so that the forced heirship rules can apply properly. Same thing applies, of course, to the client's same-sex spouse who is excluded from the forced heirship rules. That jurisdiction allows about 25% of your assets to be left however you would like. So the spouse can be covered a little bit that way. But anyway, it just sort of shows the intersection of family law, which is what largely marriage relates to, and our tax and estate planning world, and sort of the ways that practitioners that work in the international space really need to have very complete teams in the various jurisdictions where the clients are tax resident and where their assets are and where their families are. And anyway, it can just be a little bit more complicated in the LGBTQ case, because if this were a separate sex or opposite sex couple in this jurisdiction, there would be no problem recognizing even children via surrogacy in this particular jurisdiction. They would just say, fine, mother, father, register the birth certificates, and we could proceed with our usual estate planning. So there's a little bit of an extra layer for certain LGBTQ couples that they have to sort of deal with, particularly in these jurisdictions that don't have marriage equality.
So let's take the scope out slightly and let's turn to the issue of children more. And I wish to provide the same caveat that you did. Thank you, Ryan. The issue of children, surrogacy, and these issues is often one of a matrimonial family lawyer rather than an estate planning law. But we do come across this quite a lot. So it's very important in the estate planning space to be aware of these issues that are, again, more prevalent within the LGBT community, because you may have two women or two men who are in a relationship who have children, and the nature of parenthood, as understood certainly under UK law, and I imagine under US law, is still one that is baked into the concept of having one mother and one father, and that is just not the way that sometimes modern families operate. Can you talk, Ryan, in very brief terms, in very high-level terms, in LGBT families, what is it that determines who has parental responsibility over a child, depending on how they are conceived, depending on the sex of each of the parents? Might you just talk to that at a very high level?
Sure. So a traditional way that same-sex couples have become parents is via adoption. And generally, the adoption law is similar within the U.S. for same-sex couples as it is for opposite-sex couples. It wasn't always that way. And there are, without getting too far down that rabbit hole, certain adoption service providers who still will not work with same-sex couples. But by and large, if a same-sex couple wishes to adopt within any U.S. state, they can find a service provider to work with. Surrogacy is an interesting topic in the U.S. and a comparative topic among various jurisdictions, because different jurisdictions take very different views on the legality and, frankly, the morality of surrogacy. The U.S. is generally fairly open on the topic of surrogacy, including commercial surrogacy, where a surrogate can be paid for her services beyond the medical costs, which is not something we see in many jurisdictions. And frankly, it makes the U.S. in this particular way a magnet for surrogacy families that then move back to the parent's home jurisdiction. So I think it's something that it sort of creates cross-border questions. And again,
we don't allow. Almost all of the clients I have ever had who have had surrogacy questions and going down that path are doing it via the US of some form, because we in the UK do not permit you to pay the mother for carrying the child beyond meeting their reasonable expenses. And this dance is a very complicated one that is fraught with UK issues. And so it is very common that people go to the US and sort of seek those things in the US.
And with surrogacy, assuming it's sort of set up properly, and again, we're not here to really discuss all of the details of that, but there's something called a pre-birth parental order that can be obtained so that it's more of a sure thing for the parents, that when the surrogate has the child, the intended parents will have the legal rights to the child as if the child were adopted. And then the usual sort of estate planning would apply to those children. Without that, or in the cross-border context, the sort of pre-birth parental orders may or may not be respected, given some of the issues, Aidan, that you mentioned, for example. It's very jurisdiction specific, but at least within the U.S., the pre-birth parental orders are generally respected so that the intended parents are treated as parents of the children for estate planning purposes and for all U.S. legal purposes.
I think from the estate planning perspective, noting the focus of this discussion, I think what I'm seeing coming out of this as I think about it is really a reversion back to what we've already been saying, which is take advice if you are from a complicated family or a family with complicating factors, and, make sure that you are aware of who has parental responsibility. Child is legally the child of which one or both of the parents, and make sure that that is followed through in the estate plan. The easy way to do that, certainly from a UK perspective, where the recipient of an inheritance, so long as it's not a surviving spouse, doesn't really affect the amount of tax that's going to be paid, whether it's your godson, your biological son, your stepson, etc., they are all going to inherit tax exposure in the same way, is to name that person. If you are not sure, name the individual in question rather than trying to achieve it by reference to my child or my son or my children, because you will get around this solution in a very neat way, but that will not always be possible. And so take advice. Go and consider the position from the UK perspective. Go and consider it from the US perspective. I presume from your perspective, Ryan, that kind of just express naming is probably going to get you out of, if not all, certainly at least of most of the pitfalls that you might come across in estate planning.
Yes, I think that's right. Sometimes our estate planning documents are drafted before children are adopted or conceived via surrogacy. And if there's an intention for that sort of family planning, then a class of beneficiaries can be listed, as you mentioned, children or whatever, but really defining children. Generally, traditional estate planning documents will define, biological and sometimes include, sometimes exclude adopted children or illegitimate children, but to really include express reference to adoption or surrogacy within estate planning documents, especially if you're working with a client who may be pursuing that route.
And to, think about how this then applies to the final topic that I want to touch on, albeit, perhaps briefly, is thinking about how this can apply to trans individuals if you are looking to make provision for trans individuals, because the answer to this potential problem is going to be largely the same, which is to recognize people expressly by name. The UK certainly, and I would hold my hands up and say this is something that I was not aware of, and I've been practicing for some time now until I entered this further. When someone is transitioning, you can apply for a gender recognition certificate in the UK, which formally and legally recognizes the change of your gender. And by reference to the estate plan of someone leaving wealth to you, if you are someone who has obtained a GRC, a reference under someone's estate planning to my niece, who happens to now be my nephew, recognized in UK law, whether you still stand to inherit from that person's will depends upon when that person made that will, because before and after an effective date, which was from recollection in 2005, your, contemporary gender as recognized under your GRC may or may not be the way in which you inherit as you, according to the gender that you were when that will was created. And so where individuals are thinking that there are provisions that are to be made for trans individuals, again, very careful advice needs to be taken, and probably a discussion had with the recipient in question, if that's a suitable conversation to be had, about how best to recognize that person through the estate planning documents so that the correct identification is made and there can be no confusion. And again, I imagine in the US, you would advocate, that simple approach, producing probably the most efficient outcome.
Yes, no, that is right. As usual, these sort of estate planning issues are governed by state law, but generally most states are trying to honor the testator's intent. So if you're right, if there can be sort of discrepancies after a transition between my daughter or my son or my niece or my nephew, Florida generally recognizes gender identity changes. And so, again, a well-advised client will update their estate planning documents. But even if they don't, Florida law should identify who the testator intended as a beneficiary or as an heir in order to address these sorts of issues. And Florida also does recognize gender transitions under state law broadly, so beyond estate planning, as do most U.S. states. So to your point, as planners, we want to be as explicit as possible, leave as little room for ambiguity as possible. And so we would ideally update the estate planning documents. Worst case, we can fall back on some law within Florida, at least, that is a little bit more modern with respect to what we can expect with transgender beneficiaries.
So let me leave you with sort of one small note of levity, which is a campaign, a crusade that I've been on for quite a few years now, which is, in this scenario, the simple solution would be to refer to my children rather than my son or my daughter, because children is a gender-neutral term and will encompass all of your children, subject to the discussion we've just had. Children is great. It's an easily identifiable phrase. We have siblings, easily identifiable, collective, gender-neutral phrase. We have no such term in England, or I believe in the US, for nieces and nephews. There is no collective term for nieces and nephews. I am on a campaign to want to get the word nibbling into the English dictionary to refer to nieces. It's sibling with an N, and I want nibbling to be the phrase for nieces and nephews. I think the UK's English language is crying out for a collective phrase for nieces and nephews. If anyone listening to this podcast can think of a better word than nibbling, I encourage you to reach out and speak to either Ryan or me, and we'll start a formal campaign. Maybe we'll try and petition Parliament to get nibbling into the official lexicon. Ryan, thank you so much for your time. It's been hugely informative, and I imagine will mean a great deal to those looking in this space, help them in this respect. If they want to reach out and make contact, maybe if they have any questions, where can they find you?
Sure. They can find me via email, rcoyle@bilzin.com, bilzin.com. Or you can just Google my name, Ryan Coyle, Bilzin Sumberg. I'd be happy to chat on these sort of estate planning issues, any interest in the LGBTQI+ law committee of the IBA or otherwise. These issues are always quite interesting. The IBA is very active on these topics. We host sessions every year. We'll be doing the same this year in Mexico City at the IBA's annual conference. So if you're interested, please reach out on either the estate planning or the broader LGBTQ+ legal issues front.
Again, look, thank you, Ryan, so much for all of your time today. It's been immensely useful. A thank you from me to you, the listener, for joining us over this discussion. Join us again next time when we will have yet another fascinating discussion to have for you. In the meantime, thank you very much, and we'll see you next time. That's all for this episode of the UK-USA Transatlantic Tax Talk podcast. Thank you for listening. If you found this discussion helpful, don't forget to subscribe wherever you get your podcasts. If you have suggestions for a topic for us to cover, then we'd love to hear from you. For expert insights and tailored legal advice, visit colebristow.com. We'll see you next time.